different property law tools that can be applied in novel ways in order to protect urban spaces of art, culture, performance, community, as well as intangible cultural heritage. And this is in the context of the human right to culture in the city. So as part of what the UN Habitat's new urban agenda has laid out is something that's important to look at in working towards sustainable urban development in the future. And so then after I kind of look at each tool, I also consider, each within the context of Canada and our two legal systems to see how the tool in question would work or could be applied in both Canadian common law provinces and cities, as well as within municipalities in Quebec in the civil law context. So the last year, actually, I spoke about heritage easements, and this year, what I'm looking at right now, and the kind of part of the project I'm working on, looks at cultural land trusts. So both community-led cultural land trusts as well as the city-initiated form. So the public-private kind of intersection there. And so these cultural land trusts are largely modeled on community land trusts and draw more generally on the common law trust. So first of all, I'll talk a bit about what the displacement threat is for spaces of art, culture, and performance, community in the city. I mean, why do we need this tool for preserving them? And then I will turn to the cultural land trust structure and the comparative lens. And finally, I'll touch briefly on the critical study of property law as a framework that I'm drawing on, and the counter-hegemonic use of hegemonic legal tools for the urban context. All right, so what is the threat? So much of the displacement threat that spaces of art, culture, performance are facing is that they frequently are deemed to be comparatively less profitable within an urban landscape where highest and best use or the full market value of a space and its redevelopment profit potential can dominate the shape, design, planning, and policy decision-making by local government. So this slide that you can see right now alludes to a recent controversy in Vancouver that took place during the fieldwork that I just completed there. And this is where artists and a private developer clashed over what's known as renovictions, which is one of the acute challenges that many art spaces are facing. So this is Chip Wilson on the screen, and so he's one of the developers, development company. He's actually the founder of Lululemon, so you might recognize his name or him. So what are renovictions? Renovictions or demevictions essentially allow a landlord to end a tenancy by having the necessary permits and approvals in place to conduct a purported large-scale renovation such that the rental unit must be vacated. But as the term conveys, renovictions ultimately involve the eviction of tenants due to a purported large-scale renovation that subsequently enables the landlord to raise the rent of the new space, make it not affordable anymore, whether or not this large-scale renovation has in fact taken place. And there are many cases where, something quite small has changed, but it's a renovation that, justifies this increase in rent. And then we also have property taxes and the triple net lease structure. And this is another source that's led to rapid displacement of arts and cultural spaces in the city, not just in Vancouver, but in many places that have this structure. So property taxes here, where they're based on assessed value that's determined through a property's highest best use or its full market value, comprises the most probable use of a property that would return the highest value considering the legal, economic, and social factors at play in a neighborhood. And that this is kind of put in place in Vancouver, British Columbia's provincial tax assessments. But property's highest and best use may not be, as we can guess, a neighborhood art, music, or community space, a cafe with live music, local art on the walls, a small fish and chips restaurant, despite what a long time running venue, or even something like a deli, a hardware store, or barbershop, what it might add in terms of immeasurable value to a neighborhood's character. But so regardless of that, as far as tax assessments are concerned, its highest and best use could be more likely achieved with another kind of use, such as condo development. So since artists tend to be in properties with low building assessment value relative to the land value, the impact of market-based land intensive assessments disproportionately punishes them and focuses higher taxes on these studios. Now we have triple net leases. And so here the lease agreement on a property is such that a tenant or leasee agrees to pay all real estate taxes, number one, all building insurance, number two, and all maintenance. So these are the three nets in the triple net lease. So all of this related to the property, in addition to any normal fees that are expected under a rental agreement. So rent, utilities, those kinds of things. So artists are mostly on month-to-month arrangements subject to triple net contracts, which means that the artists, rather than their landlords, have to ultimately absorb the increases in municipal property taxes, which we just talked about are increasing on an ongoing basis due to the highest and best use property assessments. So now, on to slide, oops. Okay, so what's a cultural land trust here? So the goal of developing a cultural land trust structure is for the long-term security of tenure in a neighborhood alongside the possibility of sustained cultural employment in the face of the challenges that we were just talking about. So conceptually, structurally, cultural land trusts are similar to community land trusts. They don't necessarily have a predefined legal form. They can be held by a community cultural organization, an artist community, a co-op, a charitable nonprofit. And they differ in the same way that the legal form of a trust can also differ between jurisdictions. The land trust model is well established in a number of cities around North America and beyond as well. One that's well known in Canada for the Canadians in the room is the Parkdale Neighborhood Land Trust. Mainly, these are used for protecting community residential access and for nature conservation purposes, which we see a bit more in Quebec. Instead of a community land trust objective of housing or secure housing with some space for community amenities, a cultural land trust is instead concerned with the secure art space, studio space, performance space. All right, so some examples can be drawn from a few cities around the world, nonprofit organizations in these cities that I won't go into too much detail, but they've developed various forms of nascent cultural land trusts structures, and they've shaped these land trusts in a few different ways, which I unpack further in my paper. So now let's turn to more of a detailed look at the logistics of how this can be applied in Canadian cities. So first of all, what's a trust? We have the common law notion of a trust. We know that trust in common law at a basic level represents a legal relationship and equitable obligation where legal title to the trust property is granted to a trustee to hold for the benefit of another. So that being the beneficiary or beneficiaries. Property rights can, of course, be legal, they can be equitable or both. And while a trustee is considered to be the full owner and hold legal title to the trust property, the beneficiaries of the trust property hold an equitable interest in the trust property and are considered to be the owners of the trust property in equity. So in addition to the trustee and the beneficiaries, the settlor is the party who establishes the trust. It's possible for a party, of course, to be the settlor, trustee, and beneficiary of the same trust. But in civil law and in the mixed jurisdictional context of Quebec, the civil law jurisdiction that's found within the greater or the larger common law context of Canada, things are a bit different. So the civil law trust in Quebec integrated a form of the common law trust in the 19th century in order to do things like transfer assets within a family, to constitute a charitable trust. And so it was in reality mostly encountered in the matrimonial context or in the law of succession. In contrast to the common law trust and its concept of dual ownership that we just discussed, in Quebec civil law, there's no accepted distinction made between legal title or ownership and beneficial title or ownership. So the trustee doesn't have legal title to the trust property, and the beneficiaries and the settlor also do not hold any title to the trust property. So instead, the rights of the beneficiaries under Quebec civil law exist in relation to both the trust as well as the trustee, meaning that essentially there is no owner of the trust property for the life of a trust in Quebec. So the nature of the trustee's right is in the power to manage the trust property, and that of the beneficiary is to receive the benefits of the trust. So in terms of the power to manage the trust property that the trustee is granted and as an administrator of the trust property, the concept of powers incorporates the duty to act exclusively for the benefit of another or for the fulfillment of a specific purpose. So to manage the lack of dual ownership within civil law, where ownership is viewed as absolute and indivisible, the trust that appears within the Civil Code of Quebec, structured as a special patrimony, or more specifically as a patrimony by appropriation or patrimoine d'affectation, is an autonomous entity that includes the trust property itself alongside the obligations that arise from the fulfillment of the trust purpose. And the trust exists instead as a unique expression that reflects the encumbered nature of ownership, in which title to properties is held for the fulfillment of a purpose, for example, fiduciary ownership. So as several experts in the area have noted, a patrimony by appropriation, or patrimoine d'affectation, appears to be a concept that uniquely exists within civil law. So essentially, envisioning a community land trust or a cultural land trust model functioning in the civil law context in Quebec includes a dynamic fourth entity. In addition to the settlers, trustees, the beneficiaries, we have the land, with the land itself as the trust patrimony within which title is entirely bound up. All right. So for the sake of time, I won't go into further kind of minutiae in terms of the specific articles of the Civil Code that lay out what the civil law trust further constitutes in Quebec, but here are some of the main ones that I discuss. And now looking to the mechanics of application. So with the new Civil Code of Quebec, which came into effect in 1994 and replaced the previous Civil Code of Lower Canada, the earlier trust structure that appeared previously or was kind of available to be used in Quebec was transformed entirely from its prior iteration. And one key difference is that it became accessible for application to social purposes, so beyond its prior exclusively private applicability. So a social trust, turning back to the cultural land trust relevance, per Article 1270 of the Civil Code, is a trust constituted for a purpose of general interest, such as cultural, educational, philanthropic, religious, or scientific purpose, and does not have the making a profit or the operation of an enterprise as its main objective. So this looks like it's going to align really well with the aims of a cultural land trust or community land trust. But further investigation into this actually shows that attempting to shape a cultural or community land trust as a social trust is likely best avoided because it might not in fact be recognized as a charity, which it would have to do in order to fit into this social trust category. So instead, actually, it seems that it would be better to shape it as a private trust that would be a nonprofit organization and provide affordable arts and culture space to a set class of beneficiaries. So the trust would then ideally only include structurally the land itself, such that the structures or buildings on the land could then be owned, alienated, as well as hypothecated. But if this isn't possible, and if this isn't the case, then another option could be a superficiary transfer of ownership of both the structures or buildings, as well as the enjoyment of the land to a set of nonprofit organizations that would then become the beneficiaries of the land trust, as well as being able to secure ownership rights to the structures or the buildings. Then at this point, the nonprofit organizations in question could then grant leases to a defined set of individuals or members. And then beyond the structures and buildings on the land, the private trust would also be able to shape the development of the trust land to include community, art space, cultural space, or green space through the appropriation of property to these specific uses. So all this to say, and wrapping back around to the conclusion, what is the point of looking at these kinds of property law tools in this kind of detailed way that can be used to avoid displacement of and sustainability of and create space for arts, culture, and these kinds of industries that might be deemed comparatively less profitable within an urban landscape where highest and best use or the full market value of a space and its redevelopment profit potential can dominate the shape, the design, planning, and policy decisions by local government. So a major part of the critical study of property law and of trust laws as part of it is the exploration of the relationship that exists between property power and property as security. And a major concern as well of the sociological critique of property law should be to show how the ideological mechanisms of property law work, how the concept of property is or can be manipulated in legal doctrine. So property law has above all technical functions, right? It can structure the distribution and use of power in a city and in general, and it can do so in a way that can be disempowering, displacing, marginalizing. And we see this acutely, right, in the dense context of the city, and the city's engagement with private property developers, as we saw very early on in my presentation with Chip Wilson. But it can also be used in a way that limits the exercise of power and can be empowering for socioeconomically marginalized spaces, groups, and communities, and so on. And so this is kind of what the cultural lands trust structure, if harnessed properly, aims to do. So I will end there. Thank you very much. And I will transfer the host back to Ioana, or I guess I can transfer directly to the next presenter.
So the next presenter is William Ivan Aponte. And do you have, William, do you have slides?
Yes, I have slides.
Then please transfer to William directly.
Okay.
So William's
share?
So William, I see here a double affiliation. You are affiliated with the Pontificia Universidade Católica do Panama in Brazil and the Universidad Externado de Colombia.
Yes, one moment, please. I share with you.
And the title of William's paper is New Constitutional, Social and Historical Vestiges in the Activism and Functional Expansion of the Constitutional Judicial System in Colombia and Brazil.
Okay, good morning to everyone. One moment, please. Can everyone see my slides here?
Yes.
Okay, good morning to everyone. I am a student of LLM in Economic and Development Law at Pontificia Universidade Católica do Paraná in Brazil, but I am research at Externado of Colombia University. First of all, I am grateful with American Society of Comparative Law and the 2020 Younger Comparativist Committee for the opportunity to generate this space to share ideas. Thank you very much for the share of this current panel, Johanna Turkortkrit, professor, excuse me, with the pronunciation, and thank you for all of my colleagues of this panel. Okay. In this opportunity, I would like to share with you some historical and social reflections of the expansion of constitutionalism, the new constitutionalism in the activism and functional expansion in the Constitutional Court of Colombia and the Supreme Tribunal Federal Constitutional Court of Brazil. But I want to ask with you with my presentation, why Colombia and Brazil? Not only because I'm Colombian and I study Brazilian juridical phenomenon, but also because they represent this country represent two legal systems of reference, mainly in what has to do with the performance of the constitutional court, and because both Colombia and Brazil constitute two of the most unequal countries in the world, where the judicial demand for fundamental and social rights has become part of everyday life. So I will begin by highlighting two premises that my work defends. Four, really. The first one, exists a notorious interference by the constitutional judicial system in the exercise of powers that are alien to it by constitutional and law order. These interferences are due to the advent of the new constitutionalism and the institutionalism of a judicial review as insurance against an unstable political environment, marked by periods of social crisis, dictatorial periods, accompanied by an uncertainty about the competitiveness of constantly expanding market that knows no limits. The second one is that after the Second World War, the new constitutionalism in Colombia and Brazil was influencing principally or mainly by the American new constitutionalism on the understanding of constitutional justice as insurance. The third, on the other hand, we can say that exists an imbalance in favor of judges, a government of judges without limits, without control, and in some contexts, judges are protagonists of the democratic erosion, the course against democracy. And the last one, we say that constitutional justice in Colombia and Brazil has not contributed to the reduction of inequality. But what are the reasons for defending these ideas? I will structure in four main points: constitutional judge and the new constitutionalism in social rule of law, the judicial review as insurance against democratic transition and instabilities, triumphs and problems of constitutional judicial activity, the theoretical and factual approach to the activism of the Federal Supreme Court of Brazil and the Constitutional Court of Colombia, and the importance of establishing limits to judicial activism based on check and balance system. So before I want to say that I want to explain my ideas, I need to say with you that the study of this phenomenon around constitutional judicial system in Colombia and Brazil impose the analysis of certain circumstances, not only legal, not only juridical aspect, but also political, economical, social, and cultural mistakes. On the other hand, the Brazilian Federal Supreme Court, and the Colombian Constitutional Court are institutions that was created to safeguard the Constitution in the context marked by social inequality, where the guarantee of fundamental rights is more prevalent. So this was the most important. Okay, for the first part of my presentation, constitutional judge and the new constitutionalism and social rule of law, we can say that constitutional judge and social rule of law are usually identified as categories that characterize the new constitutionalism. In turn, that new constitutionalism correspond to an ideological transition represented by a converging link between judicial empowerment and constitutional supremacy. That link Judicial empowerment and constitutional supremacy is guided by a logic of insurance of the elite, which normally operate in contractually insecure environment on abstract and diffuse norms. According to Ryan Hirschnell, the new constitutionalists represent a hegemonic preservation maneuver in the United States aimed at guaranteeing privilege and certain political preference, far from considering the majority result of decision making. So the interregnum between the old constitutionalism and the new constitutionalism was accompanied by a series of events that marked the history and geopolitics of the Western world, mainly the historical period maker, the world wars. In that context, the disputes between normativism of Hans Kelsen and the decisionism of Carl Smith were settled, as well as the role of the Constitution within society, its defense and its interpretation. So it's important to say that this movement identified the true meaning of the supremacy of the Constitution and identified it as material since it is attributed to it. As substantive and axiological content, the qualities of the guaranteed attributing its protection mainly to judges, all encompassing where fundamental rights have an expansive force for law, and other establishing a regulation of principles which in turn and allows its application through balancing theory, whose word does not depart from the word of law. In the end, there's not a legal problem that cannot be constitutionalist. All things in the society, all the problems now with the new constitution, you can use to solution this problem through the constitutional justice. This also corresponds to the fact that the institutionalization of human rights are the form of fundamental rights doesn't imply a metaphysical constitution. Thus, legal or law problems will find some form and source in positive law. So in the both cases, like Colombia and Brazil, the design of a model of the constitutional state based on social rule of law, drawing on the fruits of traditional American, French, result in adoption of constitution that established a similar model of justice. Colombia and Brazil have similar model of justice. This adoption implied not only a rupture of French rule of law or a crisis of the principle of legality, but also a refundation of legality. So specifically with regard to Colombia and Brazil, as in a part of Latin America, constitutional justice has adopted certain common characteristics. What is this? The first one, an heterogeneity due to high degree of difficulty in systematizing the universe of constitutional courts, tribunal, and justice. The second one, an openness to citizens, being revolutionary in the establishment of constitutional actions, principally citizen judicial review, aimed at determining the legitimacy to exercise judicial review, and finally, a risk of hyper-presidentialism and judicial activism that altering the Montesquieu classical assumptions of the division of powers and its subsequent modification in the version of a medicine system, checks and balances. On the last point, specifically on what has to do with judicial activism and the prominence of judicial review, the ideas of the following chapter of these ideas I present. Okay, I want to continue with this point, the judicial review as insurance against democratic transition and instabilities, triumphs and problems of constitutional judicial activity. Okay, I have 3 examples here, and I ask if negative legislators And we have three cases: the partial discrimination of abortion, euthanasia or mercy killing, equal marriage through the direct application of the Constitution. Similar to 1981 Colombian Constitutional, the 1988 Federal Constitution of Brazil determined that the Federal Supreme Court is responsible for guardianship of protection of the Constitution. For its part, the Brazilian constitutional legal order following the 1988 constitutional enshrinement, in addition to a broad Bill of Fundamental Rights, a procedural toolbox to guarantee these rights and constitutional supremacy. And this is important because for its part, the Federal Supreme Court also decide cases on which a reference can be made the paradigm of judicial review based on philosophical justification of the so-called counter-majoritarian difficulty. So in that sense, it analyzes issues related to the law of protection of human life and the free development of personality. But what is the problem? If I guarantee some rights, some individual rights, what is the problem? The problem is not that judicial review as a tool per excellence of Constitutional Court and the Supreme Federal Court represent an insurance for the flaws on the institutional design, which allows to ensure the participants on the democratic gain and protection of guarantees and fundamental principles. The problem with insurance is a typical of legal issues surrounding risks is that the limits are not clear and firmly established, since it can lead to the structuring of litigation that is harmful to democracy. This is the problem. And considering this historical vision, it is plausible that the exercise of a judicial activism in Brazil or Colombia obeys a problem of uncertainty and undertaking of market in constant expansion because of a victorious of ideological agenda. So I want to present for you the theoretical and factual approach to the activism of the Federal Supreme Court of Brazil and the Constitutional Court of Colombia. I divide two types of activism. The activism for the individual but not collective guarantee of social rights. So a big part of decision of Supreme Federal Court and Colombian Constitutional Court are focused only in subject decision, individual decision of social right, but the not collective or objective dimension of social right. And the second one, the activism as a form of democratic erosion. For the first one, Brazil experienced a period of market by unbridled judicial activism, a product of the consideration or centralization on the field of analysis of fundamental social rights to the subjective dimension. This consideration was due to the transformation of a formalist and legalist Brazilian constitutional law before the 1988 Constitution, linked to the authoritarian perspective. During this period, the democratic legitimacy of the constitutional justice power was being questioned in order to establish norms of more abstract nature, since it was understood that this function. So that of bringing about the political and moral choices of society was responsible of the representatives elected by people. But the adoption of this understanding Brazilian and Colombian jurisprudence with identities in Colombian, it's similar to Colombian constitutionalism, because constitutional represent an expressive expansion of judicial intervention oriented towards the granting of positive state benefits aimed in the integral effectiveness of fundamental social rights. Some examples like decision, for example, decision to Supreme Federal Court about about leading cases where specifically a career of a rare disease of Duchenne muscular dystrophy argued that in United States there was a clinical capable to curing it without other economical consideration, cultural consideration. So I can say that on the other hand, that this is the other form of activism, in addition of the Constitutional Court recognized the unconstitutional state of affairs, that it's a tool to say, okay, all the things, all the causes for the problem are unconstitutional. And I court, and constitutional judges, I need to design different tools that involve of government and legislative programs to promote these problems. But in short, the result of the objective, the principal main of this decision, it's not only successful. And the activism as a form of democratic erosion, I can say that it refers not only the interference that impedes the adequate development and execution of political problems. In this case, the Supreme Federal Court of Brazil has been acting according to the subjective morality of its agents. In this way, it has formed a populism that is the enemy of the democracy, ignoring the legal norms, ignoring the constitutional law that define what is just. For example, I have one of these, an example of these laws of reference to constitutional is represented by some professors. The Clean Record Act, Portuguese Lei da Ficha Limpa. On that occasion, the Supreme Federal Court decided to validate the law despite its formal defects. In addition to this case, in a decision related to the powers of the President of the Republic to annul the nomination of a minister of a state considered as immoral, one of the ministers considered the existence of a right to overcome an atypical illicit that does not exist in the rule of law. Finally, the importance of establishing limits to judicial activism based on check and balance system, I can say that states that embrace the principle of check and balance system as the cornerstone of their institutional scaffolding are often in a constant public debate about the powers of each branch of government and their competence to perform the various functions of the state. Thus, as explained in previous ideas, formalistic organization systems have been overcome the concept of state organs as deontological devices whose fundamental characteristic is to exclude the practical rationality of the state function in order to avoid the overrange of institution. We need limits and control, like legality, like a rationality, like institutional harmony, like legitimacy, but not only that this legality, rationality, institutional harmony was or are writing in the constitution or some laws. We need that the discussion that arises from the judicial activity of guarantee judges may not for any reason arise from self-imposed powers or those that do not have a reasonable relationship with was established in the positive law. Rationality for what? As a limit to judicial activity includes the structuring by judges of primary evaluate reasoning, the reformulation of rules to find their adequate implementation, the introduction of exception in a systematic analysis of the legal system, and the creation new norms to solve difficult cases that are not regulated by the law. Some ideas can be deduced from the above, the final consideration. Firstly, that the judicial function within this chain of balance of powers, in addition to integration, which is the product of its interpretation function, should not only guarantee constitutional supremacy and ensure compliance with social rights, but should also be harmonious in considering the innovative power of the legislator and the need for the public administration to execute its programs and policies automatically, integrally, and spontaneously. In both Colombia and Brazil, it is notorious an interference of the Constitutional Court in the exercise of powers that are aligned to it by constitutional legal mandate. The secondly, that the activism exercised by the both courts refers to an overcoming of a judicial activity based on a philosophical foundation of the counter-majoritarian difficulty doctrine, understanding then that the activists explain here started from the recognition of a superior position of minorities that need and have access to justice. Not only one part of the society, all society need to access to justice, which arguing subjective legal position prevent objectivation and universally in the guarantee of rights. Likewise, the activism has been undermining elements of populism, which is the enemy of democracy and disestablish the constitutional process. And finally, trying to approximate the limits of judicial activism from the state shame of balance of powers in the action of Constitutional Court of Colombia and the Federal Supreme Court of Brazil, it is pertinent to give priority to legality, institutional harmony, independence, but not the independence that say the court, because we found many decisions that the Constitutional Court say, okay, judicial independence is this, or the Supreme Federal Court in Brazil say judicial independence is this. Is this the same that I did, that I say? No. We need a real independence and legitimacy. Without a doubt, this idea represents the beginning of a broad story on which it's worth generating an academic space for dissertation. Thank you very much for your time. Excuse me, my internet is not stable, and thank you.
Excellent. Thank you very much, William. This was extremely interesting. So I suggest that now we have Diana Carzon present her paper, because she discussed some extremely interesting developments in the area of environmental law. So William is presenting a negative picture of how judges operate in Colombia and Brazil in some areas of law, but they might actually have come up with extremely interesting ideas in some other areas of law. So Diana, would you like to take over now?
Yeah, so good afternoon for me, good morning for the rest. Thank you. I also want to thank for this opportunity. It's my first time, so I want to thank you all. As you said, it was very interesting. I'm Colombian, so it was interesting to see and hear a fellow Colombian as well, but I'm studying in the LLM Sustainable Development in the University of Milan. So that's why my paper is a little bit more focused on the environment. So as you said, my paper, I do not have slides. I'm sorry. Also, my internet, it's not the best. So I'd rather not have the slides and be able to talk to you. So as you said, my paper is called The Human Right to a Healthy Environment. It's developed in Latin America and Colombia. So the first question is, why are we talking about the human right to a healthy environment? We know that the concern about a healthy environment or a sustainable environment has been in the about since the last decade. We have the UN recognizing the need to have a human right to a healthy environment, but what we do not have is an instrument of universal application. So we do have a lot of regional state and regional courts establishing the right of a human, like the right to a healthy environment, but we have nothing in the universal application. But what are the benefits, or why do we talk about it? First of all, we could use the framework for human rights in attending environmental degradation. That's very important, given that the framework for human rights have been developing since the end of the Second World War, while we don't have any specific framework for environmental degradation. So by using this established framework, we could help and maybe fasten things up towards protecting the environment. Another one that's very important is that we could avoid contradictory rulings. Why? We have mainly three views when we talk about environmental protection. So we can see it from an anthropocentric view, which is environment protection seeking to enhance the quality of human life. We could see it from the ecocentric approach, that humans are just part of the ecosystem, or we can see, as always, the mixed one. So recognizing the difference between human, like the human being and the environment, but recognizing that we have overlapping values. So what would happen if we develop an environmental protection framework? Most likely it would go towards the ecocentric approach while having a human rights framework through the anthropocentric approach. So we would have contradictory rulings that contradict themselves, and we end up not protecting human rights or the environment. That's another one of the benefits that we could see in talking about this human right to a healthy environment. As such, I'm going to go directly into the development in Latin America and Colombia. So why Latin America and why Colombia? First of all, again, second, we have, as my fellow Colombian was talking, a very expansive jurisprudence and a very active constitutional court. So, and we are a very biodiverse region in the world. So first of all, Latin America, very important, our regional courts. So not only we hear a lot about the European Court of Human Rights, which it has established a relationship between human rights and the environment, but there is an advisory opinion by the Inter-American Court of Human Rights in 2007. This advisory opinion was in answer to a question by Colombia that asked about states' obligation in relation to the environment in the context of protection and guarantee of the rights to life and personal integrity. Here, the court in its advisory opinion said something very important. First of all, it recognized the fundamental right to a healthy environment. And it not only recognized the fundamental right to a healthy environment, it recognized it under Article 26 of the American Convention. Why is this important? We have the American Convention talking about mainly civil and political rights, which is justiciable. We can go to the Inter-American Court of Human Rights. And on the other hand, we have the San Salvador Protocol, which is in its majority non-justiciable. In Article 11 of the San Salvador Protocol, we do have a mention of a right to a healthy environment. What the court did was recognize a fundamental right. So by recognizing this fundamental right was that the court said there is no need to establish a connection between the environment and a violation of a human right, like an individual human right. A violation of the right to environment, it's in itself important. And the second thing is that it made it justiciable. Why? Because it recognized it under the American Convention and not using Article 11 of the San Salvador Protocol. On the other hand, in Latin America, we also have some intentions by the states. So we have the Escazú Convention of 2018. That's the regional agreement on access to information, public participation, and justice in environmental matters. For some of you that may know, it's very similar to the Aarhus Convention, that it's very applicable in the EU. The main problem is that only 9 states have ratified, so it's not very active yet, but it is, first of all, it gives procedural rights, and again, recognize in its first article the right to a healthy environment. This is talking about a little bit in the Latin American scenario. Now we go directly into Colombia. So in Colombia, I want to talk about 2 major rulings, one by the Constitutional Court and one by the Supreme Court of Justice that touch this sense of human right to a healthy environment. The court never talks about the human right to a healthy environment, but we're going to see that in its interpretation, we can talk that it's more or less the same thing. So the Constitution of 91 includes the right to a healthy environment, but not within the fundamental rights of Colombia. It has a very anthropocentric view. We use the environment as a tool to achieve other rights for the individual, but nonetheless is the starting point, as always, for the courts. The Constitutional Court established also rights by relation, so those rights that are very interconnected to fundamental rights and can be protected through something that I'm going to talk a lot, but it's the mechanism of tutela. Tutela is the mechanism of protection established by the Constitution of 91 for fundamental rights. So tutela is only for fundamental rights, and we have popular actions, I would translate it, that it's the mechanism of protection for collective and diffuse rights. In this mechanism is the environment would be protected, and we have the tutela for individual fundamental rights. So, going directly into the rulings. The first ruling is T622 of 2016 by the Constitutional Court. It was a tutela established by the inhabitants of a region in the west of Colombia of Chocó, where they were asking to protect the right to health, life, culture, and ethnic territories, given an affection on the well-being of the lands and rivers. So the main object was the affection of the rivers, lands or river, environment, why use a tutela? So the first thing that the Constitutional Court had to go and see was like, is tutela right mechanism? Can I take this? Can I study this case? What the Constitutional Court said was like, yes, it is. Even though we have collective rights and fundamental rights in the matter, this requires a wider study, a wider complex analysis. So yes, why is this important? Mainly because it puts the environment on the same level as fundamental rights. It allows communities and individuals to use a mechanism for human rights like tutela to ask for the protection of the environment. That is the first one. The final decision by the court was a very ecocentric approach. Why? Because the court understands the importance of the environment as a living organism, and as such, that it should be protected in its own right. This is an ecocentric approach at its uttermost. It recognizes the importance of the environment in its own, and it ends by saying that the Ribera Trato, which is the livelihood of the people in this area of Colombia and a very rich hydrological source in Colombia, is a subject of rights. Our second ruling is ruling 4360 of 2018, this time by the Supreme Court of Justice. This again is an answer to a tutela, this time by several children of the Amazon forest. Their main issue, the problem of deforestation and how it's affecting their lives and their future livelihood. Again, the court needs to answer, is tutela the right mechanism? Should be a popular action? The court said yes, tutela is the right mechanism. And again, using this ecocentric approach, established, and I'm going to quote here, the respect for oneself implies respect for the part of itself that is composed of nature and of which future generations will part. In other words, we are one with the environment, and the environment cannot be seen merely as a tool. With all this argumentation, the Supreme Court of Justice in Colombia made the Amazon forest a subject of rights. So what do we see with these two rulings? First of all, the use of human rights mechanisms to access protection of the environment. This is the base of what a human to a healthy environment could achieve. The use of established mechanism, the human rights mechanism in achieving the protection of the environment. And second, we see that by using this tool, we have two rulings that give rights to the environment. Not only two rulings, we see also the opinion by the Inter-American Court of Justice that also recognized the environment as one, the environment as a subject of rights. So this is how the development, or how we have seen the development of the human right to a healthy environment, both in Latin America, this is recent, and especially in Colombia. Now, my last part, which is something I want to focus on the future, is the importance of recognizing the human right to a healthy environment in transitional justice mechanisms. So why I think it's important in peace building and conflict resolution. So as we know, conflict involves environmental damage. Big, small, it always involves that. So by achieving this human right to a healthy environment, we can also utilize this as a tool to achieve a durable peace. Here, I'm going to talk a little bit about the peace process with the FARC and the special peace jurisdiction. So during the peace process, they found out, or the studies found out, that more than 60% of the hydric resources in Colombia had been affected by the conflict, being by oil leaks, or by attacks, or by illicit exploitation of minerals. Also, the problem of deforestation has been very, very important due to conflict. So we see that the Havana Pact and the whole process with the FARC has had a very environmental focus, especially the part regarding the rural area. It's very important to talk about the peace process, about the redistribution of land, but it's not only redistribution, it's correct management that has to be achieved through government, private entities, communities, and individuals. In this area, we see all the sustainable development principles, the focus we have on the environment. Here is also very important to note that the State Council in 2015 told the Colombian government that they had to include environmental reparations in the Havana Pact, given a problem or given a case regarding Andean oil pipeline. So what is the main problem with the Havana Pact talking about the human right to a healthy environment? First of all, it's anthropocentric view. Again, we touch the environment as a tool to achieve other fundamental rights and not as a subject of rights in itself. And the second is that in the Havana Pact, there are no mechanisms of repair or repairment to the environment and of avoidance of future degradation. So here comes the special peace jurisdiction. The special peace jurisdiction has a very broad objective. Within, we have the satisfaction of rights of victims, the protection of the rights of the victims, achieving truth, contributing to peace. If we see this general objective, we see that nothing directly or indirectly touches on the environment. So we have a Havana Pact, which is very much in sync with principles of environmental and of sustainable development, but we see that the legal ground has nothing to build upon that. So how does the special peace jurisdiction uses previous developments by the court in Colombia and its own? It's going to use a lot the concept of crime. Why? Because it's so broad that allows for things like environmental issues to be touched. Here we see two very important statements by parties of the special peace jurisdiction. The first one is the statement by the Investigation and Accusation Unit in June 2019. What did they say? They simply recognized the environment as a silent victim of the conflict. So this is an immense statement. Not talking in specific terms, talking in general terms about the whole environment in Colombia, recognizing that it as a silent victim. Why? Because of damages and alterations, because of different things, and vowing to search for mechanisms in order to achieve its reparation and no repetition. This is, again, we see another judicial court leaving the anthropocentric view and going directly into the ecocentric view, victim as subject of rights. And also we see that it's not isolated. It's been a construction in the Colombian jurisprudence. It's been a construction in the Colombian judicial sphere. As well, and more specific, we have the Chamber for Acknowledgement of True Responsibility and Determination of Facts and Conducts. This is in November 2019, that in their investigation, 002, recognized the Capsasu. The Capsasu is the environment for the Agua people as a victim. So in their investigation to certain crimes committed in the state of Nariño, that's the southwest of Colombian territory, the chamber understood that the Agua people and their territory were inseparable, so that they could not only consider the Agua people the victim, that they should consider the territory that they lived in as a victim itself. So again, seeing this ecocentric approach where the ecosystem has rights of its own, and it can be taken to court, can be considered a subject of rights. Here, and as you have seen both in transitional justice mechanisms such as the special peace jurisdiction and in the Constitutional and Supreme Court, we see indigenous beliefs, indigenous communities. And I think that's very important. It takes us away from a very Western conception of the environment and could help us shape a new right, the human right to the environment. It's very difficult to understand the human right to the environment if we only think about the Western view of justice, the Western view of conception of the environment. So I think this is really important. That's one of my conclusions. The other one is that using human rights mechanisms to achieve environmental protection does work. We can see that they recognize it. We can see that we can find rulings that go hand in hand both with human rights of the individuals and of the human right to the environment. The importance of recognizing the environment as a subject of right, the importance of recognizing the environment as a subject of right that can give this protection without needing it to be related or interconnected to individual human rights. For me, it's very important. It should be a very important topic for post-conflict societies and transitional justice mechanisms. It could be a way to avoid no repetition and to avoid conflict. And last of all, the importance of regional and national courts. We've seen the real development of the human right to a healthy environment through the use of courts, through the use not only of human rights mechanisms, but the use of courts in national and in regional areas. So this was more or less my presentation. I hope you liked it. And if you have any questions, I would love to answer. Thank you very much.
Thank you, Diana. It was extremely interesting. Okay, so we'll come back to you with questions and comments. So let's hear now the presentation by Aaron Skillich, right, on whether use tokens can incorporate combat against poverty. Excuse me. Yes.
Hi everyone, thank you very much, Yona. First of all, I would like to thank Younger Comparativist Committee as other people, because it's not easy for master's students to be eligible even for conferences. And I am Arınç. I am joining from Lund University. I'm LLM student at International Human Rights Law program here, and also a research assistant. All presentations were really interesting, I think, and I'm really happy to meet other LLM students here, especially. And I have a simple PowerPoint presentation. Can I share simply? Or?
Absolutely, just a minute, I'll make you host.
Oh, thank you. Okay. Yes, I think you can see my slide now, right?
Yes, we can see.
Yeah, okay. Okay, now I can start.
You might want to click on presenter view though.
Sorry, I'm doing firstly in
all the slides.
Yes. Can you see now?
Yes, thanks. Yes, excellent.
Okay, thank you. Okay, today, as it was told, I will talk about whether Uskogan's norms can incorporate the current trend to combat against poverty. It's a bit, yeah, it was a very interesting topic for me to explore while I was preparing this research paper. Yes, I can start. Initially, enforcement of economic, social, and cultural rights is still a controversial topic among international lawyers, as we know. Whereas some argue that human rights are universal and these rights cover economic and social rights, others argue that economic inequalities fall under state policies and lies outside of international human rights law. Besides this ongoing discussion, we can currently see that poverty is one of the issues which international human rights law mechanisms are trying to deal with. In this paper, my aim is to discuss the possible elevation of combat against poverty to the level of Uskogen's norms. For this aim, I will first present the contemporary concept to combat poverty in international law. Subsequently, I will discuss the case law regarding poverty from regional mechanisms. Later, I will describe the American legal process theory as a methodology to identify Uskogen's norms. And ultimately, I will argue that even though the alleged dichotomy between negative and positive rights was rejected in the Vienna Declaration in 1993, the current situation proves that the dichotomy is indeed still inherent to the international human rights law regime. So now let's talk about the international recognition of combat against poverty. It's not possible to assess and show all instruments related to poverty in international law in this paper. Thus, I will focus on the United Nations instruments, and I will believe that those instruments reflect contemporary trends. Mainly, there is no binding legal instrument to eliminate poverty in international human rights law, nor is there an agreement on a customary law on this topic. Poverty has been taken into account in its relation with other rights, for instance, as a reason for deprivation of some fundamental rights and entitlements. In the United Nations Guiding Principles on Extreme Poverty and Human Rights, it is indicated that poverty is an urgent human rights concern, and it is both reason and consequence of human rights violations. In fact, it's emphasized that eradicating extreme poverty is not only a moral duty, but also a legal obligation under existing international human rights law. Here we can see that the fact to be eradicated is extreme poverty, but not poverty itself also. Moreover, the Committee on Economic, Social and Cultural Rights provided that discrimination based on an individual's socio-economic situation for the enjoyment of rights prescribed in the ICCR is prohibited, and the equality principle requires state parties to ensure the protection of rights of people living in poverty condition. Due to the fact that the ICCR is a binding legal instrument and the committee is the responsible body for the implementation of the covenant, it can be concluded that state parties are obliged to address the disadvantages of people living in poverty conditions. However, it doesn't imply that poverty is itself a violation of the covenant. We can see that there's a similarity between right to an healthy environment and poverty issue in this regards. It's taken into account with its connect relation to other rights and entitlements. Now, I will talk about how regional human rights tribunals approach poverty. But firstly, Patrick Glenn claims that states are no longer nation states and that there is a trend to resort to non-state law. Additionally, he suggests that other normative claims which don't fall under existing law have been already incorporated within the public international law. Although in the combat against poverty context, I believe that these two arguments fail. And this failure crystallizes the fundamental ethics of the current situation. Indeed, regional human rights mechanisms don't show an optimistic feature for other normative claims with regard to poverty conditions. For instance, European Court of Human Rights didn't recognize poverty as a discrimination ground in Garib versus Netherlands case. And Judge Pinto criticized it in his dissenting opinion by condemning the court for not recognizing the social precariousness of the applicant. And in Koufaki and Adede versus Greece, the Greek government had decided remuneration reductions as a response to the economic crisis. And when applicants challenged that decision, the court referred to margin of appreciation doctrine and found the application inadmissible. As another example, however, more progressively, as it is in other fields as well, the Inter-American Court of Human Rights recognized poverty as discrimination ground in relation to the right to education in Gonzalez versus Ecuador. Although applicant family in poverty conditions, although the court didn't analyze how the state of Ecuador could and should have supported applicant family in poverty conditions. By doing so, the court didn't consider poverty as an autonomous human rights problem to be eliminated. Therefore, again, I argue that there is no possibility of any ethical claim, such as freedom from poverty, in existing international human rights law. Despite the fact that a moral ground to combat poverty is presented within the UN Human Rights Council, a broad legal perspective is not applied in regional mechanisms. Now I will talk about jus cogens norms, and I will ask the question that can American legal process theory incorporate the duty of eradicating poverty? American legal process theory deals with jus cogens norms and provides a methodology to identify norms that can qualify to be considered as jus cogens. According to the American legal process theory, judges should look at the objective evidence generated by the international community to fill legal gaps and to interpret positive law. By departing from this point, O'Connell suggests a community-centric methodology to identify jus cogens norms that relies on judges' reasoning on the basis of the evidence in the positive law to identify the fundamental principles that are superior to the positive law. This methodology includes soft law documents such as UN General Assembly resolutions and declarations. Until this point, there is not an apparent conflict between American legal process theory and the contemporary trend. Because if the United Nations resolutions are one of the instruments that may constitute superior norms, the UN guiding principles on extreme poverty could be taken into consideration for a possible jus cogens norm. Although, even if a judge finds sufficient evidence in addition to UN resolutions to identify the superior norm, American legal process theory would not incorporate this type of norm. According to the American legal process theory, jus cogens norm solely can void a treaty or a domestic regulation, or can place rights corresponding non-interference duties. It means that jus cogens norms cannot place affirmative duties on states correspond basic human rights. Indeed, these basic rights can correspond to only non-interference civil and political rights. In other words, due to the recognition of jus cogens norms as superior ethical or moral norms of international law, American legal process theory excludes socioeconomic positive rights from the superior ethical norms and rights. Thus, there cannot be a jus cogens norm such as freedom from poverty due to the fact that it demands positive measures in our given social system. American legal process theory is based on economic realism and it doesn't serve socioeconomically vulnerable groups. In fact, this theory confirms the Marxist critique that the international human rights law serves free market interests rather than serving public as a whole. However, it's inconsistent. This theory is inconsistent with the United Nations rule of law philosophy. In Vienna Declaration 1993, it is suggested that all human rights are universal, indivisible, and interdependent and interrelated. Despite the fact that the alleged dichotomy between negative and positive rights was rejected in the declaration, the underlying ethics of international law shows that it is challenging to embrace the equality of negative and positive rights. To conclude, as Glenn indicates, when international law is challenged with new normative claims, underlying ethics is revealed, and poverty is one of those challenges, I argue. In this paper, I attempted to reveal the underlying ethics in the identification of jus cogens norms. I believe that it is considerable progress after the UN Vienna Declaration that today eradicating extreme poverty is defined as a moral duty. Although we are practically not at a place that the UN rule of law philosophy points out. Despite the theoretical denial of the dichotomy between positive and negative rights in the Vienna Declaration, in practice, there are challenges for the adoption of socioeconomic rights to the extent that civil and political rights have been adopted. Therefore, we should question the structural foundations of international law and narratives of international human rights law that has been constructed on, I claim. Thank you very much for listening.
Thank you. Could you please make me host again?
Okay, I will try. Make host.
Excellent. So
Yes.
do you have any questions, comments on any of the papers?
I still have to present my paper.
Yeah.
By the way,
Matt,
yes.
any comments on those? Are you also on our panel? I don't think so.
Yes, I am.
Oh, I'm sorry. I didn't see you. I saw only 4 presenters. Oh, I'm so sorry. Please go ahead. And I didn't receive your paper. Please go ahead.
Oh, I'm sorry. I don't have a PowerPoint though, so you'll just have to listen to me talk. I'm sorry about that. But yes, so my paper is on land reform in South Africa, and I've been doing a comparative study of land reform in South Africa versus Zimbabwe. And I wanted to give some context and background information first. So when we talk about land reform, what I'm talking about is also referred to as land expropriation without compensation, whereby the government expropriates land from current landowners and redistributes it to those who do not currently own land. The issue here is that in the Republic of South Africa, since apartheid, there has been a provision of the South African Constitution, Section 25 of the Bill of Rights, that provides for the government to expropriate land, compensate farmers, or excuse me, the landowners who are typically farmers, and redistribute it on an equitable basis. The original goal in 1994, when the first democratic elections in South Africa took place, was to have redistributed about 30% of land by 1999. We still haven't reached that number. It's, I think, less than 10% even today. So there have been calls for an expedited process and without compensation. I was going to discuss for a little bit the significance of poverty to human rights, but the previous speaker, I think, did such a great job of that I'll skip over that, except to say that poverty has been described by the UN High Commissioner for Human Rights as a comprehensive assault on all human rights. And so the abject poverty in South Africa, which is particularly impacts people along racial lines, has a particularly egregious effect on human rights, considering that human rights are specifically meant to be guaranteed without discrimination on the basis of race. So yes, it's been about 26 years since the first democratic elections in South Africa. It's been 23 years since the current South African Constitution took effect that provided for land expropriation. And it has been and it has been even longer since the end of apartheid, but these disparities are still really, really significant. For reference, white South Africans make up less than 9% of the population in South Africa, but they own, as of 2018, 72% of privately owned land. Meanwhile, Black South Africans, who make up 80% of the population of South Africa, own about 13% of privately owned land. So the disparities are huge and have an impact across social issues, healthcare outcomes, education outcomes, and employment and economic outcomes are all really, there are huge racial disparities in all these areas. And a large part of it can be linked to the sort of disparate ownership of land and resources. So why is this up for discussion now? In 2018, when President Ramaphosa took office, he promised to expedite land reform. This following increased calls from certain members of his own ruling ANC party, as well as the newly formed Economic Freedom Fighters, or EFF party, that have been really pushing for an expedited land reform program. The particular push is to amend the Constitution, Section 25, to allow for a legislative decision on how land can be expropriated without compensating its current owners, and then redistributed, basically to make it so that the South African government can begin to expropriate land at an increased rate and without paying the compensation that it has been up to this point. And this is important because the reason expropriation has been going so slowly thus far is that South Africa operates on this willing buyer, willing seller model, which is that they won't purchase land unless the current owner is willing to sell it. And at that point, the government will purchase land and redistribute it. But because the process has been moving so slowly, there's been a push to both expedite the process and purchase land forcibly, and to do so without compensation. And the reason I was interested in this particular topic of comparing with Zimbabwe is that the arguments against land reform in South Africa, both domestically and all over the world, tend to focus on Zimbabwe as a cautionary tale, sort of a case study for why land reform does not and can never work. Zimbabwe underwent its own land reform program in the 1990s under then President Robert Mugabe, and by all measures, it was completely unsuccessful. Zimbabwe was subject to hyperinflation, loss of investments and foreign investment income. The country of Zimbabwe, which formerly was a food exporting country, now is food dependent. It needs to import food just to feed its people. And most of the land was concentrated among a wealthy few. Mugabe himself and his cronies in the ZANU-PF party. He needed to do so in order to help maintain power. So the comparative perspective of my paper was meant to be an answer to this argument, a statement of not just why is it so important to conduct land reform to reduce poverty and the outcomes that I described, but also why it can and will be successful in South Africa, where it was not in Zimbabwe. And the reason for this is that South Africa, briefly, is a very different place than Zimbabwe of the 1990s. South Africa today has a burgeoning civil society. It has its own free press. There are increasingly powerful opposition parties, including the EFF, to the ANC. And because the South African constitutional amendment that will take place provides for judicial oversight, and South Africa's independent judiciary is widely respected. So there is still room for South Africa to conduct this process equitably and successfully. There's also requirement that under the new provision, the legislature may take steps to set when the compensation for land will be nil. It will not be mandatory that the compensation is nil, which was the case in Zimbabwe. And the South African government is committed to doing this in a way that is careful not to overly trample on the rights of the current landowners, insofar as that's possible under this kind of system. So in addition to being a necessity in South Africa, there is a lot of reason to believe that this program will be very successful. There are, of course, some downsides. There is still rampant corruption in the South African government. It is far less than it was a few years ago. President Ramaphosa has conducted reforms, and the empowerment of these opposition parties has helped to keep the ANC in check relative to where it was a few years ago. And South Africa's rights-based constitution has sort of focused attention on the need to improve health disparities, economic, education disparities, and land reform is the way to do that, both as a matter of distributive justice and as a matter of future progress in resolving some of these outstanding issues. I'm conscious of time and that we want to leave time for questions, so I'll end there. But thanks very much, everyone.
Thank you. It was extremely interesting. We could stay a few minutes over if you would like, if you have any thoughts to add. Okay. Okay. So do you have any questions, comments on papers? Yes, please. Michael.
Yeah, so thanks for the papers. The good news is I did read Matt's paper. So if you don't have any questions for Mariana, I do. So yeah, so I have one question for Matt and one question for Deanna. I'll start with the question about the right to a healthy environment. I was wondering, you mentioned a few times that there was a problem with treating the human right to a healthy environment in an anthropocentric manner. And I was wondering if you seem to take this for granted. And I was wondering if you could explain to me your theory of legal personality that makes that problematic. And in particular, explain to me how it is that we can have a human right to a healthy environment that isn't anthropocentric. Do you have a theory of legal personality whereby I, as a human, can have a right to another thing that has a legal personality? Can I have a right to a corporation or something like that? And then my question for Matt is, I guess, when I was, what you say is intriguing, but I'm wondering what evidence there is that the problems in Zimbabwe can be rooted in a lack of judicial review, and that the South African court is well suited to address those problems. It seemed to me that a lot of the problems in Zimbabwe weren't simply a function of a lack of judicial review, and that there's reasons to question whether the South African Constitutional Court can serve as a proper check on any problems that we can attribute to them. We know that ANC has functionally just been the equivalent of, you could say, of some of the parties we've seen in Zimbabwe. But we've also seen a really hit or miss history of the Constitutional Court being able to, for instance, address health-based inequities, despite the fact that there's a right to healthcare services. So why think that they're going to be better able to address these problems insofar as we can identify them? Thanks everybody. I could have asked questions for everybody, but I'll just stick with those two for now. Thanks.
Would you like to respond, Matt and Diana? Matt, first maybe, since we'll follow reverse order.
Sure. So yeah, I think the judicial oversight is one of a number of aspects that I think working together can help to make South Africa's land reform program more successful. The Constitutional Court has had trouble in the past with guaranteeing the rights that are provided for in South Africa's Constitution. But there have been a number of successes, I think, in South Africa that have shown that when opposite to maybe public view or even to maybe the ANC's own preferences, the Constitutional Court has pushed South Africa towards recognition of these rights, even in a progressive way rather than an immediate sort of demand. One thing that comes to mind immediately is same-sex marriage in South Africa, which was provided for, by the Constitutional Court, despite more broader opposition. But the constitutional provisions in this case were pretty clear that this was a requirement, and the Constitutional Court did not sort of immediately say grant legality to marriage equality, but rather prompted the South African legislature to come up with its own plan to do so, and the result was within a specified time frame, and the result was that they did in fact guarantee this right. So I think in that respect, at least, there have been some successes, and that's why there's reason to be hopeful that the independent judiciary, I think, will act as a check. I know there are limitations still in what it's been able to do more recently, but that, in addition to sort of this growth of opposition in South Africa to the ANC, but both on the left and right in terms of these new political parties, that have their own demands on how the land reform process takes place. Obviously, with one side calling for a much more expedited and less compensatory program, and the other side wanting to be more circumspect. I think the result is going to be that this is going to play out in South African civil society very openly. In contrast to Zimbabwe, which, yes, the problem wasn't just the lack of judicial oversight. The problem was that the land reform was used as a tool of corruption. It was used as a tool to sort of provide certain powerful individuals in the Zimbabwean ZANU-PF party, the economic elite and military leaders with these sorts of benefits as a way to keep their support for the ZANU-PF regime. But the ANC still enjoys broad support, and in addition to the sort of oversight from civil society and the judiciary, there's simply not this sort of that extreme level of cronyism doesn't still exist in the country. There are issues, but especially in the wake of the end of the Zuma presidency, I think there's a lot more attention being paid to the actions of political leaders.
Diana?
First of all, thank you very much. It is a very difficult question, the one you pose, and I thank you for it because it gives me an opportunity to reflect and to include it in future papers, because I'm willing to continue my research on this topic for my master thesis. So I thank you very much for your question. As I said, given the difficulty of the question, I don't know if I could completely answer it, but one of the first things that come to mind, or that I would like to answer, is exactly that. The problem with, not the problem, having an anthropocentric view of the environment, it's not harmful in itself, but it is a complex view if we're talking about the human right to a healthy environment. Why? Because it's not the individual transmitting its right to an external thing. So it's not the same as the individual giving the right to a corporation or to some external aspect. It's circumspecting, or it's including the individual into a bigger thing, and that bigger thing is the environment. That's why we talk about an ecocentric view, because it's not the individual opposed to the environment, the individual that's giving the rights to environment because of their connection. It's the environment acting at itself. The main issue and the main problem with that is agency. Who is going to be in charge of those rights? The environment cannot act for itself. It's impossible, no matter how many rights we want to give it or not. So the main problem would be the agency problem. So that's the way I would like to answer, or partially answer, your question, because I know it's not a full, complete answer to everything you asked.
Yeah, terrific point. And courts have been innovative recently and expanding the understanding of legal personality in many respects, right? So you're discussing here that the Amazon River was recognized as having rights, and I think courts also in New Zealand have recognized rivers as being the subject of rights. And in the US, corporations have been recognized as being the subject of rights, right? We might have, and there is discourse also of corporate social responsibility, right? So if we start expanding the concept of legal personality in so many other areas, why not do it also in the area of the environment? So that there's a lot of room for you to be creative here, right? Michael, why don't you ask your questions also to the other participant? You're muted.
Yeah, I was actually, this isn't even a direct, so I had a question for William, but now I actually want to switch to a different one in light of what Matt just said. And I'm kind of wondering, given what some of the concerns you were raising with the judiciary in the countries that you were talking about, if you have any thoughts about the extent, I kind of want to put your paper into conversation with Matt to sort of ask, for your general thoughts and reflections on the extent to which judicial review serves as a safeguard as sort of the distorting effects of these different issues. Sorry, that's not terribly clear. And the other thing I just wanted to say, I said in the chat, if anybody's interested in these legal personhood questions, Visa Kirky's new book is really fantastic. And he also talks about artificial intelligence as another place where we need to be thinking about these legal questions. And when we talk about rights to stuff, we have these rights to technology, right? Well, if these things also are things that we have rights to, then maybe there can be a sense in which we have a right to something that itself has legal personality. And that's really fascinating. And I think actually starts to link up with some of the issues we were talking about even in Sarah's talk, where we talk about sort of these odd things we might have rights to. Like, do we have a right to a collective? A community? Do we have a right to that, even if it has its own legal personality, right? Like, it might be that the sense in which the best legal form through which to protect your right to a culture is actually some sort of corporate entity or that has its own legal and independent legal personality from you. But then you somehow have a right to that is very interesting. So actually, let me also to put things in perspective, sort of instead of the original question I had for Sarah, now that I'm freestyling, Sarah, do you think that there's something interesting there about your right being instantiated best through these sort of private entities, which may themselves have legal personality? So sorry, William, if my question's too vague, sorry, but I'll let you speak to it. And if not, Sarah's, my question for you is, I think, better.
Yeah, who would like to respond first, William or Sarah? William?
Sarah, if you want, you can start.
Sure. Yeah. Thanks, Michael. Yeah, I think that's what's, a right through a private entity or private thing, and that's something that I didn't, when I started doing research, I didn't really know where it's fieldwork based, so I didn't really know where it was going to go, what it was going to end up with. And I think the kind of these private entities, right, with the Cultural Land Trust represents, really, it's interesting. And I think I'm troubled by it because I think I can see it going either way, right? So you have something that's generated by a nonprofit or by a community, right? So then you have this entity, and then they can kind of keep the space, the community space, or what have you. But then you also have the city generating it, and then kind of create this way for the community to remain. But I mean, the problem is, I guess, when we think about private entities or what they can represent, or corporation, it seems kind of counterintuitive to think about putting all these kind of artistic folks and kind of saving their spaces through this a corporation or a private entity. And I guess my concern is that there's a bit of this, like replication of power problems, right? So the idea is you take it out of the public, you put it in the private, and that's the way, you can actually have meaningful protection where that's just not being afforded right now in the city, in terms of how they're dealing with other private interests. But then at the same time, my concern is that, decision-making, again, within this private entity, as within a corporation, can have all sorts of internal abuses and so on. So I think that's something that troubles me. And then I was thinking too about this, idea of spaces having rights. And I mean, that's interesting. Yeah, with the right to technology, but then what if technologies are, and I'm thinking about, cultural space, and I work a lot with this idea of intangible cultural heritage. And so we protect heritage, spaces and buildings, but, I'm interested in the protection of fabric. So I'm thinking about, like, how would you work through something like the actual intangibility, or the fabric being some sort of having a life in and of itself? I don't know. So I'm gonna keep thinking about that. That's interesting. Anyways, thanks for your question. I'm not sure if I answered it, but yeah.
William?
Okay, I'm going to answer the question. My internet is a bit slow. I am not in the city, so excuse me if when I speak, you don't understand all my thing. Okay, I have to warn that this is a work in progress. Yes, the focus of which is to analyze the impact of judicial decision on equality and your equation in like land reform. Yes, or more than inequality, that the effectiveness of rights. Yes, we have in Colombia some decisions, some structural decision. We have 3 structural decisions, and I think that one of these it's concerned to the topic that you want to state. One of these is one moment, please. One of these decision is this the displacement, nah? And this decision, this structural decision of the Constitutional Court of forced displacement. The topic that you can find of this is the land reform. Yes, because many or one of the elements of our conflict, of our long conflict in Colombia was the land. Yes, so in this, mostly from a structural decision, what we have found are symbolic rather than material decision. Yes. On the other hand, I am a little critical of decisions that recognize the rights of natural elements. Yes, we have analyzed the activism from the causes, but not from the effectiveness of the consequence. So mainly the rights protection, we don't have a material social change with constitutional and judicial decision in Colombia. Yes, for example, we found 2 or 3 works about the consequence of the impacts in the protecting rights in the inequality of the decision, and we found that it's symbolic decision in the land reform, in environmental rights declaration, and in all of the majority of a big part of social decision, we don't have a really change in our social society, in our society.
Okay, that I have a question, which is, I think, a terrific follow-up to the comment you just made. So why do you think that the courts are not appropriate? They are not the appropriate institution to bring about social change in Colombia? Because all those cases that you have cited here, same-sex marriage, euthanasia, decriminalization of abortion, those are very progressive decisions in some respects. Right? And in many other parts of the world, also courts have come up with innovative solutions, and it's actually the courts that have brought about social change in those areas. What do you find particularly disturbing within, let's say, the Colombian constitutional system, that it is coming from the judges and that those decisions are not properly justified, so that, let's say, the requirements you analyze there of legitimacy and rationality are not met? Because in other parts of the world, the Canadian Supreme Court, for instance, right, has issued an extremely interesting decision on physician-assisted suicide. And this is considered to be a very innovative decision and very advanced compared to what is happening in many other parts of the world. So what is the problem? And also in the area of environmental rights, we heard Diana, the court has been extremely creative and innovative as well. So what is it that you find particularly disturbing? So you think that in other cases, related to social rights, like the ones you mentioned, they engaged in activism that reduced the positive action of the state and the real rights that citizens could enjoy. So is that a problem? And that the justification and the rationality behind was not persuasive, was not good enough?
Okay, I know that when I say that Colombian Constitutional Court is a reference to progressive decision, this is a reality, more than Brazil Supreme Court. But what is the problem in this? I think that the problem in the recognition of social rights more than individual rights is that social right is not recognized in its objective component, in the collective component. So when Supreme Constitutional Court or in Colombian Constitutional Court is recognizing more rights, okay, that is very, very progressive. But when the court recognizes one law, the court recognizes for one person, for one man, for one woman, for one child, for one group of the society. And many times when, okay, the court say, today I protect the right to health from forced displacement woman, yes? And when the court recognizes this right, she doesn't say what is the impact of the economic decision, the social decision of the court doesn't have doesn't analyze about the decision. So only recognize the right, yes, the court recognizes the right, but only in a subjective perspective, not a collective perspective. So all people say and all people show and all people see the Constitutional Colombian Court like, okay, the best court in Colombia, the court that recognizes all of the rights for people, but more than the decision of recognize their rights for people, it's what is the impact? If for all the society, if my decision it's for reduce the inequality of the society or only for satisfy one right for one man, for one woman, for one member of the society. This is the critical, this is the other part of our constitutional court.
You wouldn't say that, let's say, a court decision may have served as a catalyst for the parliament to intervene and regulate and establish a rule that would apply for a number of cases. Your problem is that the courts are just issuing individualized decisions, and it's not right, that have a very, very limited scope. So it hasn't been the case that parliaments, after court decisions, actually enacted rules.
And I think that we have a big problem. I think that, for example, in one part of my study, I say the problem is not only the justice. Yes, the problem it's not only the constitutional court. The problem is the institutional design. We don't have a good institutional design. And this reason, the consequence of the reason is that we don't have a good legislative. We don't have a good government political design. For example, and this is the reality in Colombia and Brazil, we have two constitutions. In 1991, we have a social constitution, and in Brazil in 1988, we have a social constitution. Nice. We have a constitution that recognizes the rights, that recognizes all social rights, all fundamental rights. But we don't have a government that is according to the elements of the constitution. For example, in Colombia, since the constitution of 1981, we don't have any government that is according to the elements of the constitution, to the protection of social rights. This is an ideological design of liberal position, or this is more a social position. For example, in Brazil, we have another transition. Since 1988 to 2002, we have a liberal government. So the constitutional content of the 1988 constitution, we don't have a ideal development. Since 2002 to 2016, we have a government that starts to change this possibility to guarantee the universal education, to guarantee the health right. But after, we have a constitutional court in Brazil that was a part of democratic erosion, and we return to the old things that we found with the constitutional rights in Brazil. We return. So what happened? We don't have an ideal institutional design. Our constitution don't correspond with our reality. Okay, now what is the question? I read some constitutional professor, I remember Richard Albert in one tweet, he said, okay, but if we don't have constitutions that are effectively, that guarantee all the rights, we need to change our constitution. And one of my professors say, no, but if we didn't have this type of constitution, we didn't guarantee one right. Now we have some rights. We have an advance for this right, but now we don't have a real, effective, and guaranteed a law that guarantee all the situation. So the court, it's a part very, very important. Yes, but it's not only. And what happened with us? All things was judicial things. All things are constitutional things. Okay, all constitutional things are judicial constitutional, have a judicial constitutional process. We need to change this focus. Many authors in Latin American authors like Roberto Gargarella, like Mark Toshnet, he started about the popular constitutionalism. So this is the reason for return the constitutional to people. But okay, people are very manipulated. If I don't have the control with people, what we have? So we need a dialogue constitutional law in our countries, but with limits, because we need judges, independent judges. I think that all judges are political judges. I think this is my position. But we need a dialogue that occurs. But what is the objective of the aims of the dialogue? We need to guarantee social rights. We don't have only for judicial court, only for legislative, only for the government. All parts need to dialogue to guarantee our social design and to guarantee an equal institutional design.
Excellent, thank you. Extremely interesting. So, Sarah, I had also a question for you. Why do you think that the private trusts are better than social trusts in your analysis? And then I was wondering also, you're describing in your paper how trusts for culture have been organized in various parts of the world. And I was thinking, did you get a chance to think at all as to whether maybe some experiences may be better than others, and maybe some of those trusts have something to learn from the other's experience? Did you detect any significant differences in how those trusts are organized or institutionalized in those various parts of the world that you're studying there?
Yeah, thank you. So, so basically with the private versus social trust, I think that's specifically related to civil law and the iteration of the civil law trust in Quebec. So my initial impression was that, social trust would be a better structure, right? Considering it has these, kind of aspirations for equitability and charitable organizations, that kind of a thing. But the reason why the private trust thing is kind of a better option is simply because the way that the kind of the language of the article dealing with social trust works in the Quebec Civil Code is that the cultural land trust structure or the community land trust structure wouldn't fall under the charitable category, oddly enough. So because it has some kind of profit mechanisms in how space is meted out or land is meted out. So that's the reason why I think the private trust structure works better. So just the logistics about how you would apply it under that particular civil code. As for the other trusts around the world, and that's been really interesting because there's such a variety in how these land trusts can be structured. So there's a couple of instances, one in Scotland that's been interesting in how they work with artists, and their focus has really been on this idea of intergenerational justice, preserving cultural spaces for artists, for the present artists, for future artists, and also for what's kind of framed as the greater social good. And that's really kind of city initiated. So that's interesting to see, the role that local government can have in shaping an organization like this and kind of having a culture as human right focus. In the US, there's a couple of interesting examples, and kind of in a different way how they structure it. So it's much more artist-driven, community-driven, and so their artists are much more involved in actual decision-making processes, which I think is something that's interesting to learn from. But then also how much, when artists are involved and their interests are involved, how they end up having to kind of draw a lot on private funding. And so in the end, even though they have more of a kind of a say in the decision-making process of what spaces look like and how they're maintained or preserved in terms of the land, it can actually be the voice of private development that can end up coming through the artists. So that, so I mean, I think there's something interesting to learn from all the different structures, and especially because they're quite diverse. Yeah, so I think that there's definitely something for all of them to learn from each other. And then ideally, we can come up with a perfect structure, but I doubt it.
Well, that could be a terrific project in itself, right? To investigate. Right. So, Arend, also I had a question for your presentation and paper. So I was thinking, so you don't seem prima facie to be able to discover something like a positive obligation of the state to combat poverty at the level of international law, at least. But I was thinking, the law is to a great extent also a matter of interpretation. Can you be creative in interpreting existing international law legal tools in order to come up with an obligation of the kind? So how do we fill legal gaps? Either we enact legislation or we are inventive and creative with the legal tools that we have. Is it entirely impossible for you to just think creatively on the basis of existing legal instruments? So it's unlikely that it will come from, let's say, the European Convention on Human Rights, although it's not entirely excluded. That court seems to defer too much to the margin of appreciation of the state. But other legal instruments that exist at the level of the UN?
Okay, thank you very much for this question. I think there are, like in the scholarship, there are several attempts for this actually, like some scholars actually try to interpret the International Covenant on Economic, Social, Cultural Rights, especially the article about right to life and right to health actually with its components, to oblige state parties to eradicate extreme poverty actually. There are some attempts, I know some PhD thesis about it from Oslo University, but unfortunately I forgot the name of the author, I'm sorry. But yeah, in practice still, unfortunately regional courts haven't interpreted broadly yet actual regional conventions. There are there are recent, some recent interpretations. For instance, the European Court of Human Rights in spring, basically urged Serbia about living conditions of Roma population, actually Roma minority, and they publish interim measures to Serbia act on, basically, because, and they said, European Court of Human Rights said that it's degrading, they connected to right to life, basically. But again, in general, regional courts are not optimistic in that sense, I think. Even like I personally find African Court of Human Rights and Inter-American Court of Human Rights more progressive in general than European Court of Human Rights. But even Inter-American Court of Human Rights is a bit, skeptical about it. This is the current state of case law, basically.
Terrific. That's a terrific area for future research for you as well. Can you actually think creatively about existing legal instruments at the international level, or would you suggest possibly a new international instrument?
I definitely suggest new international instruments. Definitely, I think because interpretation also is an activity, not only a technical activity, but also an activity which we analyze the normative nature of the sources, also legal sources. And as I actually tried to argue in this paper, that international human rights law, normative nature of international human rights law is unfortunately not ready to claim the equality of positive and negative rights, I think. So I think we definitely need a new perspective in international human rights law.
Excellent, thank you. Any other comments on any of the papers? Do you have comments on somebody else's paper? Those of you who have presented, maybe? Any thoughts, questions, possible research avenues for the future? No? Okay, so we have to end the session because we are well beyond our time, our allocated time, so hopefully this doesn't create any problems. So it was truly wonderful to hear your presentations, extremely interesting topics, all. Yes, and very nice to meet you. Thank you very much for joining us. Good luck with your studies in the future.
Thank you very much.
Thank you.
Very much. Bye.
Bye.
Bye-bye. Thank you. Thanks, everyone.